Good morning and welcome to Panel 7, the scope of state authority to control litigation. I was, after listening to all the panels yesterday and anticipating what we have coming up, I was going to go ahead and self-declare this as the champions panel, but then I learned that Chip Miller is a Buckeye, and so in good conscience, I simply cannot call us the champions.
Champions and the national champions.
But the rest of us are going to try to overcome. So. The format's going to be similar to what we had yesterday. We're going to open up with 10 to 12 minutes of kind of an opening remarks by each panelist. Then we're going to have some responses to those opening remarks, and then we'll have the Q&A. I'm going to briefly introduce each panelist, but as indicated yesterday, all of the fuller bios are in the conference program. Professor Margaret Thomas is the Associate Professor of Law at the Louisiana State University Law Center, where she's been a faculty member since 2011. Before that, Professor Thomas taught at Berkeley Law, practiced law as an appellate attorney, and clerked for Judge Pamela Ann Reimer on the Ninth Circuit and Judge George King on the Central District of California. Professor Thomas wrote one of the articles on today's reading list, the Parens, Patriae, and the State's Historic Police Power, published in the SMU Law Review. Chip Miller is counsel to the Ohio Attorney General Dave Yost. Before that, Mr. Miller served on the Ohio Court of Appeals, practiced commercial litigation, and clerked for Justice Maureen O'Connor on the Ohio Supreme Court. He was involved in the Sixth Circuit action on behalf of the state of Ohio that we heard referenced during several panels yesterday. And that petition that he worked on is found in today's readings. I did check the order that denied that action, and none of the judges on that panel are in the audience today, so I believe we are safe.
I will fire for effect.
Savit is the elected prosecutor of Washtenaw County, Michigan. Go Blue. He was elected in 2020, and before that, he was a legal counsel to Mayor Duggan in the city of Detroit, where he led the city's plaintiff side litigation work, including opiate litigation. Prior to that, he clerked for Justices Ruth Bader Ginsburg and Sandra Day O'Connor. He also represented sovereign clients in environmental matters, including the states of Maryland and New Jersey and the Commonwealth of Puerto Rico. And he teaches local government at the University of Michigan Law School. Vaishali is partner at Hinshaw and Culbertson in Chicago. She defends companies and actions brought by state attorneys general and local governments. She spent close to a decade in the Illinois Attorney General's office, focusing on consumer protection. During her tenure, she frequently led multi-state investigations and litigation related to advertising, marketing, and promotion on various topics. And I forgot as I was reading all this that we've agreed to use first names, so from now on I will go ahead and use first names. So Maggie, why don't you start us off?
Thank you. I want to thank all of you who are here so bright and early this morning, and I especially want to thank the Law and Economics Center for allowing me to participate in this wonderful program. The panels yesterday were fantastic, and I'm looking forward to the rest of today. So as I was thinking about the topic today, it occurred to me that it's worth asking whether we are living in a golden age of parens patriae actions, or perhaps defendants might say a dark age. We heard yesterday that parens patriae actions exist outside the limitations of class actions, and I want to talk a little bit more about that today as we lead into our panel. These actions sometimes walk like a duck, they quack like a duck, but the Supreme Court has told us they are not ducks like class actions. So the idea is to explore what they are. Why do we have them? And all the ways that we constrain class counsel in Rule 23 class actions in federal court simply do not apply. There are no opt-out rights. There is no mandatory judicial settlement, judicial oversight of the fairness of settlement. And the careful scrutiny of certification simply is not part of the package. And so whether this exemption from class action rules is to be celebrated or to be scorned, I think is a policy discussion that reasonable people disagree about, but that's not my topic. What I want to hopefully convince you of is that Parens Patriae actions, whether you like them or not, serve a different purpose than Rule 23 class actions. Rule 23, according to the Supreme Court, is a joinder device. It's part of the core of the federal rules we use to bring multiple parties together. That is not the purpose of Parens Patriae actions. Rather, they are a feature of federalism. And they're not about convenience or efficiency. You might even say they're about the opposite. They're about the messy inefficiency of federalism, and the things we're going to discuss today, I think, will put that on full display. So why do we have them? Why do we need them? What's the role? When I first started looking at Parens Patriae actions right after the Hood versus AU Optronics case came down, trying to figure out why they're so different, I came away deeply confused. The Supreme Court has been inconsistent in explaining why we have them, what the source of them is. If you follow the citations in the cases back, they lead essentially to nowhere. And so I had to do the research myself to look way back in time, going all the way back to the framing, to see if we could find the roots of them. And what I found were multiple origin mythologies. And mythologies plural, where courts were coming up with different origin stories as to why these exist, but those stories don't often have a firm foundation. So the first one that you'll frequently see cited in cases, I dubbed the sovereignty transference theory. The idea is the king was guardian of the realm, and at independence, the American states received this guardianship power to now apply in their own right. The only problem is it isn't true. When you dig into the English history, there was not a royal prerogative to have transferred in the way the courts have claimed. And that English history is complicated. It's in my paper if you're a history buff and want to dig into it. But the takeaway is that origin myth is not true. The English crown did not have that kind of royal prerogative to have transferred at the time of independence. So we can put that one aside. It's quaint, it's lovely, but it's not true. Then around the 1830s, Justice Story in the Supreme Court came up with an idea that that I call universal sovereignty, which he said was an idea that the states derive this power to sue and enforce Parens Patriae powers by virtue of what it means to be a sovereign. It's just inherent in the idea of sovereignty. The interesting thing about that, though, is because it's just a story, the way that he reasoned common law was to always look at universal principles, divine what the general universal principle was supposed to be, make common law based on that, and that would supplant any sources of positive law, including state law, to the contrary. So in engaging in this form of reasoning, there was Pennsylvania common law to the contrary in terms of the power at issue. But he used this universal federal general common law that he divined from universal principle to supplant state law. You can't do that anymore. That's been knocked out by Erie Railroad versus Tompkins. So that form of federal common law making power to create these state common law rights that exist as a matter of universal principle because of federal law, that doesn't happen. So post Erie, we can't have that form of law as a source. You could have state common law, you could have state statutory law, you could have federal statutory law as we do in antitrust, but this form of generalized federal common law as an origin story is no longer viable post Erie. So the only other competing theory in the case law that kicks around but hasn't been well developed is one that the court has called modern sovereign or quasi-sovereignty, which is almost an analogy to the states being like little nations. And so they have powers analogous to nations, came out of the 19th century, and is rooted in a lot of different areas. It has supported the growth of modern Parens Patriae. It it came about the same time the doctrine exploded in the 19th century, and it helped support the expansion of the doctrine into health law and environmental law in the 19th century, where states started reaching out into more and more areas. And then in the era of industrialization, as the states were trying to figure out how to regulate these new economic things that were happening all around them, Parens Patriae became one of the ways that states used litigation to try to regulate these new industries. It was an era of expanding state police power in the 19th century. And so the quasi-sovereignty theory understood states to be able to assert their own common law power, evolving and changing with time, including a power to take up the claims of individual citizens, to essentially espouse the claims of their individual citizens. And that was over a century ago. In trying to figure out why this doctrine has existed and been so robust, though, my research suggests that we ought to really be thinking about Parens Patriae power as part of the state's police powers. It moves in tandem with them. As they expand, so too does the way that states use litigation to assert those powers. The power exploded in the 19th century, just as the Supreme Court's doctrine of police powers started to gel and mature. And the police powers have been understood as elastic, reflecting social and economic and political conditions, and so too have these Parens Patriae powers. But what this means is curtailing those Parens Patriae powers is not like tinkering with Rule 23, because it's not a joinder rule. It means shifting the balance of federalism, which is a significantly different undertaking if one were to try to curtail the state powers, and is indeed something that would be a decision belonging to political branches and not courts. And if I'm right that Parens Patriae is best understood as a mirror of these then existing notions of police powers, I think one of the takeaways is that the organization of the police powers and the assignment of them is up to each state. And we are not going to have one answer as to how these powers get assigned, but we're very likely to have 50 answers, because they may be delegated to cities or to counties or other forms of political subdivisions. They don't have to be delegated. A state could choose not to delegate them. But those choices are going to involve the specific histories of the state, the incentives, and the political reasons that are likely to be hyper-local and not having an easy federal answer. So who should decide whether delegation has occurred? It seems to me that in the absence of clear legislation or state Supreme Court guidance, if you're in federal court, for example, in multi-district litigation, the best a federal judge is going to be able to do is to make an eerie guess. And those are often fraught with problems. Certification to the state Supreme Court to get an answer would be a wonderful opportunity if the state allows it. Not all states do. Otherwise, I think federal judges are potentially looking at some abstention problems, and we can talk more about what those problems are in the Q&A. But hopefully this introduces the doctrine, and I look forward to my co-panelists discussing it in more detail.
Great, thank you. Chip?
All right, great, thank you. Maggie started by thanking Don for the invitation to come here to speak. I've been coming to these panels a couple times, these events, in the audience, and he came up to me the last one I was at, and he said, hey, would you like to be on a panel? And I said, yeah, I'd love to. And he said, well, then, in exchange for that, you have to stop shouting questions from the audience. And so Matt reminded me of that yesterday, and I was good, and I sat on my hands, and so here I am. So I guess to kind of just talk about the issue generally, kind of picking up where Maggie is. Parens Patriae existed long before the class action. It existed long before the MDL. So it is, one of the first ways that the courts came up with to handle major problems, and it was for the state to do so. And these are powers that have been vested with states' attorneys generals, going back, 100 plus years now. They've been there for a while. Maybe they're getting dusted off a little bit, but that's okay. But we do have good guidance, from precedent, even from the U.S. Supreme Court on the extent of these powers and who possesses them. And so to kind of talk about these a little bit with respect to opioids, because that's kind of, currently what's going on where it's kind of most acutely seen. But there are other issues as well, and maybe be able to hit on those. But it came up because we have the states that were suing the opioid manufacturers and distributors. And we had some local governments that were concerned because they remember tobacco. And they didn't like how the funds got spent that came in from tobacco. And we have some plaintiffs' attorneys and that had represented states in tobacco. And we heard from some of them yesterday, who didn't like the idea necessarily of having their fees limited, like they are in many states, if they represent the state. So we have the alignment of these interests here of some governments, local governments are looking to get more funding. And we have some, enterprising plaintiffs' attorneys that say, I want to be paid what the market will bring for my work and not what the state statute limits me to. So if I represent some municipalities, I can get, 35%, 40%, whatever, instead of 5%, I'm limited if I represent the state. And so that created the market. So after the states started suing, counties and cities started suing as well. And a lot of those got consolidated before Judge Polster in the Northern District of Ohio. And Judge Polster summarized it thusly. He said, the problem is that there are a number of states, any money that is a state attorney general obtains, either by victory in court, litigated judgment, or settlement, goes into the general fund. And then he discusses specifically the problem with what happened in the tobacco litigation. It was seen as a problem as far as, more than 90% of that money was used for public purposes totally unrelated to tobacco, smoking, lung cancer, or whatever. And I believe that's why we have all of these counties and cities that filed separate lawsuits to make sure that it doesn't happen again. Any settlement has to address the problem of putting money into the state general fund, or else it isn't going to fly. And ladies and gentlemen, I suggest to you that that's not the role of any court. That's a political question. And it's a political question left specifically to the states. And it's certainly not a role of a federal court to decide how money should be allocated within a state. And so, we were participating to some extent, along with many other states, in negotiations that Judge Polster was facilitating. And there were a couple letters that were sent by groups of attorney generals, kind of expressing concern, about the fact that these local governments were asserting, essentially these kind of these public nuisance claims. That we were hearing about that yesterday, that really do, belong to the state. They're the same claims, and they're seeking monetary payment for that. So it's not just like, hey, turn off the pollution. It's give us money as an equitable remedy. And so, and so that's why we have this kind of acute problem. If we're both going there, so I had another kind of similar case that was not in this realm. It's an instance where there was some public corruption, and some energy companies got more money than they should have, and we were looking to stop some of those fees. Well, we had some local governments come in, and they filed a Me Too suit, but they were just looking to turn off the valve. That's the same thing we were doing. So, like, if they win and we win, that's fine. We both win the same thing. And but here, where it's a monetary remedy that we're seeking, there's a problem. And so we went to the Sixth Circuit and filed a petition. Arguing some of the points we'll go through here now, and it was decided not on the merits. Basically, the panel that we got, and since we lost, I call it a bad panel. We got a bad panel, and they decided to that we should have actually appeared in the district court, which we thought we had state sovereign interests that meant that we didn't have to. So they kind of ducked that issue. But the issue is alive and well, in some other matters, and will continue to come up. But so specifically, the Supreme Court has said in a case called Alfred Snap and Son that if the health and comfort of inhabitants of a state are threatened, the state is the proper party to represent them. That was in 1982, and it was cited back to a case from 1901. And the case has also kind of addressed this political subdivision. The court has also addressed this political subdivision issue. It was county commissioners versus the city of Boulder. And there the Supreme Court said, we are a nation not of city-states, but of states. So these Parens Patriae powers and authorities, belong to the state, and they're not there to be exercised. I'm sorry, Don, I didn't see it. Okay. By the local governments. And again, in a case coming from my state, City of Columbus versus Ours Garage, the principle is well settled that local government units are created as a convenient agency to exercise such governmental powers that the state must entrust in them at its absolute discretion. Whether and how to use that discretion is a question central to state self-government. And so when we have, a situation to where we have these collective actions, where we have, all of these local governments coming together, and there was even this weird kind of class that was proposed. I mean, what is being created there? If you've got kind of a class of local governments that's kind of being, things are decided what's going on, maybe by members of local government, maybe by kind of the attorneys that are representing them. I mean, it's almost like you're creating some other kind of quasi-governmental entity that then is competing with the states themselves to decide how the state's going to resolve these funds. And so, yesterday, we heard from one of the MDL PEC committee members, Jennifer Scullion, who went to BU like I did, so she's smart. She explained that although there's been a $26 billion settlement negotiated and reached, we're still having trials going forward because the local governments haven't signed on yet. I mean, that's that's a problem, and it's being tolerated right now. And probably if you kind of go through and you look at the actual law that's out there, it probably shouldn't be tolerated. Now that doesn't mean that there's not the ability for local governments to bring their own claims for their own damages, but at the same time, if a state comes in and resolves and settles the claims statewide, that's going to be effect, and we're going to continue to see this. There's a spinoff MDL right now before Judge Breyer in the Northern District of California, where he's kind of teed that issue up. So we'll see that, so stay tuned to see where that goes. I think we'll see it in PFAS litigation, we'll see it in climate litigation, we'll see it in Juul. So, I know that Jim Hood, when he was sitting here, said that, hey, we're not going to see this much more, but he's now one of the attorneys that's out there kind of representing these governments, and so I think he's, maybe saying, hey, look the other way because we want to keep doing it. Maybe I'm being a little cynical there, but that's. So at least color me suspicious, I guess. And other than that, I have no strong opinions on the matter.
All right, let's hear from Ellie.
Well, thank you, and just like my co-panelists, I want to thank the Law and Economics Center for inviting me here. I will tell you that when I got the invitation, the real selling point was that I could go into SEC country and sit next to a Buckeye and remind everybody that Michigan football is 7-0. So I'm just that concludes my remarks. But no, I want to focus on the power of local governments to sue as plaintiffs, including as Parens Patriae, and their relative authority vis-a-vis their parent states. These are not questions, I don't think, that can be answered by sort of abstract invocations of state sovereignty or of state superiority. Now, obviously, states are sovereigns, local governments aren't, but what local governments are fundamentally is administrative subunits of the states. They are fundamentally state entities. And so the position that I want to lay out is that the authority of local government to sue, including the power to cloak itself in the state authority to sue as parens patriae, is fundamentally a question of state law and needs to be resolved by reference to state law, in other words, to the rules that the state has set for itself. So let's start with the sort of basic principles. States are sovereign. The case Chip cited is absolutely right. States are the sovereigns. We're a nation of states, not of city-states. Local units of government are not sovereign. What localities are, in the words of the Supreme Court in Hunter versus Pittsburgh, is they are convenient agencies, state agencies that is, for exercising such governmental powers as the state sees fit to entrust them to exercise. Now, there's been, as to parens patriae and local government's ability to sue as parens patriae, there have been a series of drive-by rulings in the Ninth and Fifth Circuit most prominently, which say basically, look, parens patriae is a sovereign privilege, a sovereign authority. States are sovereigns, local governments aren't, therefore you can't exercise parens patriae authority, local governments go away. What I think is that those rulings are at the very least incomplete, if not misguided. Specifically, again, local governments are agencies of the state that the state can fill up with whatever power it chooses and allow them to exercise. Those governmental powers necessarily, I think, include the ability to sue wearing various hats, right? That is a governmental power that accrues in the state, and the state can give those to local units of government. It can take them away. It can deny local units of government that. But again, that is a question of state law, and there is no reason that the state cannot delegate to a local unit of government, to a city, to a county, to any other subdivision, any of its litigation authority, including the authority to sue as parens patriae. Now, I want to take a step back and say that, look, at first blush, I get it. It may seem odd to say that a state sovereign can delegate to a non-sovereign entity its sovereign authority. But if you really look at it, that's what states necessarily do as a matter of course. Yes, states are sovereign. Yes, states have sovereign litigating authority. But states don't write legal briefs. States don't show up in court. States don't make argument. People do. People do under the authority of state law. And it's only because state law entrusts certain agencies and certain actors to do that, that the individuals, typically through the AG's office, are able to go into court and invoke state sovereignty and parens patriae authority. Now, look, there's no reason that that necessarily has to be true, of course. And I realize I have an audience of many attorney generals, so I love you guys, I respect you guys. But look, y'all aren't sovereign, you guys are people. Fundamentally, there's no mention in the Constitution of state attorneys general. There's mentions of states. Yes, every state has an attorney general, right? Yes, every state has decided to imbue the state attorney general with the authority to go into court and exercise the sovereign powers of the state. But fundamentally, an attorney general's office is an administrative subunit of the state, just like local governments. Both are, in the words of the Supreme Court in Hunter, convenient agencies for exercising the state's governmental power. So if litigating authority, including parens patriae authority, can be delegated to the state attorney general, there is no conceptual reason why that cannot be delegated to administrative subunits of local government as well. And notably, per the Supreme Court, the state can delegate, and indeed many states have delegated, to more than one entity the authority to speak on behalf of the state. Karcher versus May is a Supreme Court case in which held that 2 New Jersey state legislators could intervene in a case and speak for the state, even though the AG didn't. As explained later by the Supreme Court in Hollingsworth versus Perry, that case stands for the proposition that though the agent that speaks for the state is typically the state attorney general, state law may provide for other officials to speak for the state in federal court, and federal courts are not going to second guess that determination. So those are the general principles. Practically, where does that leave local governments in the real world? Well, states regularly delegate significant litigation authority, including, I will say, Parens Patriae authority to local units of government. Just a couple of examples as to how this can be delegated. One is through specific statutory delegation. And, you know, I'm a Michigan prosecutor, so what I'm going to do is cite a Michigan statute which provides that, quote, the prosecuting attorneys shall appear for the state or the county and prosecute or defend in all courts of the county all prosecutions, suits, applications, and motions, whether civil or criminal, in which the state or county may be a party or interested. So that's a statutory delegation that expressly gives locally elected prosecuting attorneys, county prosecutors, the authority to litigate state interests in court. In other states, there's the interaction between Parens Patriae authority and home rule. Home rule is a broad system of local government which provides either via the Constitution, the state constitution, or via a statute that local units of government have all of the powers that the state has unless those are expressly denied. Now, one of those powers is, of course, the power to go into court, the power to sue as Parens Patriae. And indeed, at least one state court has expressly held, this is out of Delaware, that by virtue of the broad delegations in the Home Rule Act, local units of government have the authority to sue as Parens Patriae, not on their own, but because the state has delegated that power. It's not a new local power. It's local units of government, the administrative subdivision of the state, exercising that power. So that leads to the practical question: how do we resolve suits where, you know, the state attorney general and local units of government are on different sides? Now, this tension isn't new. In the in the late 1990s and early 2000s, there were the gun cases that were filed by a number of cities. And when the state said, look, we don't want you bringing these suits, they had a way to do that. The legislature passed a law which said, states, thou shalt not bring these suits. And that's an entirely appropriate and kosher way of doing it. Again, the state is the ultimate superior sovereign here, and they can set their own rules, and they do that through legislation. But when you have something like the opioid litigation, where both sides are involved in the lawsuit already, and fundamentally the question is who is the right party to bring it, this is not something that just should be resolved by reference to the state's superior sovereignty. I agree with Maggie. There are going to be 50 different statutory schemes, 50 different rules that are set up as to who can exercise state's authority, because indeed every state has set different rules for itself. And that is fundamentally, by reference to state law, the way in which courts should determine whether these suits by local governments should yield or whether they can go forward. And in many cases, I don't know every state law, but in many cases, that is going to lead to a situation in which both parties are able to continue bringing their suit, possibly as Parens Patriae, but certainly through the litigation authority that has been delegated to local units of government by the state itself.
Given that Vaishali represents defendants, I think Ellie just made her nervous. So, Vaishali.
I was already nervous before Ellie started talking, so no, I think thanks again to LEC, and I remember, you know, I was an AAG in Illinois for more of my career than I've been a defense lawyer, and so I remember being in the audience, and it's nice to be back, and thanks also to my co-panelists. You guys are clearly very well regarded in your respective fields. So I am gonna, you know, there's been a lot of talk about these being abstract questions or theoretical issues or ones dating back to 1900 and kings and queens, and we don't have those here. And I am going to try to make it as practical as possible because these are very practical issues that I think both AG's offices and companies are dealing with. And so let's start with the practical, and I'll kind of weave in some comments to some of the things that my co-panelists have talked about. I guess one of the things, and the judge mentioned it, you know, and I keep emphasizing my background, I will get to a point here with it, is that, you know, for over a decade, close to a decade, not quite over, I handled multi-state cases for an AG's office that was very activist. And those cases spanned all kinds of topics. Pharmaceutical products, a national foreclosure settlement where there was a big national foreclosure crisis, student lending cases where there were major national problems with financial services, the delivery of that financial service product. And I've spent, you know, a little over a half decade now defending companies who are facing those actions from AGs, local governments, or the federal government agencies. And I'll tell you, you know, there's a lot of differences in the cases. There's a lot of things that are different in the marketplace, or a lot of differences in the history of what leads up to those resolutions. The one thing that doesn't change is there is a trajectory in the arch of the case. And it always goes like this. The company is on one side, and the prosecutor is on another side, and it seems like a straight line. And as the case continues, and as the parties talk, the straight line starts to bend, and eventually you get to the point where you are trying to reach the same goal. That is the case in every single case I've ever handled on either side of the table. And in reality, that's probably the case for a lot of negotiations. It's particularly so for companies when they're dealing with the government. Companies do recognize that there's value in cooperation with the government besides the cost of putting it behind you. And besides simply just kind of closing a chapter, there is value in trying to be at the table and resolve societal problems. Majority of companies I've ever represented recognize that. And similarly, majority of companies I ever prosecuted recognize that. And the reason I emphasize that practicality of that is because what we really should be doing is we really should be trying to see how quickly and how efficiently we can bend that arch to get the two sides to be talking to each other. Yesterday, we heard a lot from a variety of different great panelists about the role of AG offices. And I think without a doubt, all AG offices, regardless of political party, regardless of location in the country, all AG offices are trying to protect a public interest. There is something big going on, there is something brewing that makes AG offices look into particular types of conduct. And when we talk about, you know, what's getting to a resolution, we really have to think about, are we putting in place impediments to getting the public relief, or are we making the system more efficient? And so one of the reasons why, you know, the perspective I'm sharing is about kind of letting AGs play the role they're supposed to play, is because it's the most efficient outcome. And it's also the most efficient outcome for the judiciary, because it really helps avoid expending resources on what are essentially the resolution of public interest issues. So it does relate to some of the things, I think Maggie set it up really well, which is, there are differences in the way different states look at parents' patriae authorities. But there is a central point where every state comes together, and the central point is that the state attorney general is the chief law enforcement officer of the state. All states articulate it differently. Some articulate it from common law, some articulate it in the Constitution, some articulate it by way of statutory authority from usually an attorney general type enabling statute. But all states say the state attorney general is the chief law enforcement officer of the state. And so again, there are some parts, I think Eli and I agree on, that political subdivisions are administrative arms of the state. What I want to, I guess, throw out there is that when the AG takes an action, like sending a CID, sending a civil investigative demand or a subpoena, when the AG decides to file a lawsuit, when the AG is in the middle of conducting an investigation, potentially talking to witnesses, looking at inspecting books and records, taking sworn statements, potentially in the middle of a litigation, or when the AG has already resolved a case, that is the state's, that is the Attorney General's expression of its sovereign ability to make a decision on that matter for the state. And so I don't think it's as simple as saying, well, the state can delegate the powers. When the state has already expressed its authority in that domain, it is not delegating that power. And so the state is actually expressing, hey, we're interested in opioids. We're interested in the foreclosure crisis. We're interested in tobacco and any number of other cases. And so, again, think about where local governments are actually investing in the cases at issue. Or sort of where are local governments attempting to exercise parents' patriae authority? They're not doing it on every single case an AG brings. They're not, the AGs bring gazillion cases, you all know that. Your press pages are full of cases. Local governments are not going in and saying, oh, but AG took action, I need to take action there. Local governments are picking and choosing the cases that they believe have the highest value. And I'm not going to debate whether that's right or wrong, but that is in fact what's happening. They are looking at where there potentially are, if you put it positively, I'd say they're looking at where there might be harm to their residents, and it might be broad spread harm. And if you maybe take a little bit more cynical approach, they're looking at where there are deep pockets to recover. Here's the deal. That is the exact set of circumstances where the AG should and has expressed its interest, where there is great broad spread harm across the states, and often the AGs are acting in a coordinated fashion across multi-states. So this issue of when local governments actually exercise parents' patriae authority is a little bit circular. The states are expressing vis-a-vis their attorney general their willingness to actually protect the public interest. And in fact, the states are the appropriate role to do that. So I guess I would just submit that I'm not sure the attorney general has delegated any authorities to, as a practical matter, to local governments in the types of instances and cases we're talking about. Is it possible an attorney general in some states could delegate authority? Possibly, but I don't think that's what we're talking about here. We're talking about situations where AGs have already acted and spoken. And I'll just bring it back to those practical points I talked about. I can't underscore them enough. It becomes very difficult for companies to settle with AGs when there are major roadblocks to bending that arch. If you cannot bend that arch efficiently you start to where it becomes a prisoner's dilemma. Let's everyone just stick to where our positions are because we can't see where there's an ability to meet in the middle. And I think that's a problem for all the parties. That's a problem primarily for the public in trying to resolve and bring justice on issues of national import.
Great, thank you. All right, so I think we've set the table well. Do we want to spend a few minutes going through just reactions that you all have had to each other's presentations so far? Go ahead, Maggie.
Sure. One of the things that I've looked at in other contexts in multi-district litigation is the path to global peace. Is there a path to global peace? What's the function of complex litigation? And I think most complex litigation scholars agree that the goal is settlement and global peace. And one of the things that I think these cases make more difficult is the path to global peace. Once upon a time in the old days when class actions were much more robust than they are now, you could have a nationwide class action where there is one settlement that could settle everything for everybody who had a then existing claim potentially, but those days are long gone. We don't really have those anymore. So multi-district litigation was supposed to pick up the mantle and provide that path to global peace, but sometimes there may not be one within it, as we're seeing in opioid litigation, just because of the conflicting interests. But I think perhaps what that suggests is that there is a political problem within some of the state subdivisions. There are some states where it appears that the states and their subdivisions play as a team. They litigate like it's a team sport, and they figure out how to support each other. There are other states where they're competitors. And I think that creates a huge problem to settlement. So it may be that new tools are needed in order to create more team sport playing and less competing for all of the people at the table, and I'm not sure we have that solution yet.
So, Parens Patriae is not an authority for a state legislature to delegate. It's an executive power. It's the power to appear in court and to litigate. And so perhaps it can grant some powers to local governments, but it cannot do so at the expense of the state attorney general. And when you go to court to litigate on behalf of the state, it is true that sometimes there are different institutions that can speak for the state. What the heck, a quick analogy. So, like you go into a Catholic church and it's time for the Eucharist, they'll have, if you go where I go, you got 3 or 5 priests still up there. And, sometimes one will speak, sometimes another, but they're all they're chanting the same thing. Sometimes they'll speak in unison. But they're all conveying the same message. If one of them starts doing something a little bit different, that's where there's a problem. They're speaking with the same voice. It's okay when they're working cooperatively. But when they're working against each other, even the United States Supreme Court says there's one voice. There has to be one voice that is the state that's speaking. Others can come in as amicus or in other kind of, forms and have their say, but there's one that represents the state. And somewhat on point, the Supreme Court just heard arguments about who speaks for the state and who can substitute in a case from Kentucky, Cameron versus EMW Women's Health. So sure, there is questions of, who speaks for the state. But if Parens Patriae authority can't be delegated, or at least cannot be taken away from the Attorney General, when the Attorney General speaks with the voice, it is his voice. And, the choir boys, from the local governments have to sing along, or be silenced, Or another analogy, it's a parents, right? So parent. So I'm from Cincinnati, so is Jerry Springer, right? He used to have these shows all the time, who's the father, who's the parent? And not one of those shows did he ever say, you're 75% the father and you're 25% the father. It can't be. Perhaps the parent will sometimes, delegate some authority to the oldest sibling to kind of take care of some of the younger kids, but that doesn't make that sibling the parent. The Parens Patriae authority resides with the Attorney General completely and totally.
Let's move to Ellie, and I want to give you the opportunity. I know one of the questions that you wanted to address, and I think this might be a really good time, is we've heard about the efficiency arguments with regard to having locals not involved, but you wanted to maybe touch on areas where everyone might want the locals involved. So maybe you could touch on that?
Sure. I'm happy to, but I, just because Chip, I can't let a Buckeye get the last word. Look, states are the unit of government that we're looking at in the federal system. The case that Chip cited is exactly right. We are a nation of states. We're not a nation of city states. We're also not a nation of attorney general states. And so when the state makes a decision as to how it is exercising its power, that is the decision that should be respected, and it does so through the legislature. This is not a question of the Attorney General delegating to local units of government Parens Patriae authority or authority to litigate. It's the question of how the state, through its legislature, through its laws, has filled up the various buckets of powers, and it can do that at a state level. I mean, states don't have to have an Attorney General. States don't have to have local units of government. Every state does, right? But they don't have to. They can set up their government functions however they want. And so, by that logic, I don't understand why a state could not say, and indeed many state courts have recognized this, why states don't say that, look, Parens Patriae authority exists through local units of government because that is something that we are delegating to them in our power, our state power, to organize our governmental functions in the way that we see fit. And, I think it's a modest proposition actually, is that courts should respect what states say about their own exercise of state power. Sometimes that means that local lawsuits need to yield to the Attorney General. Perhaps in most cases, in most states, that there is a law on point which provides that. But we've got to resolve these disputes by reference to the rules the state has set for itself. Now, there's certainly efficiency questions. I do not dispute that. I will note again that if it is something that becomes so untenable and is really holding things back, the state legislature can always make a change to the law, just as they did with the gun suits, where they effectively stripped local units of government of the authority to bring suits against gun manufacturers. But to answer your question, Judge, there are a number. We're talking about multi-district litigation and opioids and the like, but in the abstract and in your mine run of cases, there's a number of circumstances in which a state may actually want local units of government to take sort of a more proactive approach to litigation. One, very simply, is that a citizen of Ann Arbor is also a citizen of the state of Michigan. Local units of government are likely to be more attuned to issues of local concern. A consumer protection violation that is limited to, for example, the city of Ann Arbor, a pollution of a local stream. And, having empowered local units of government allows those issues to be resolved more quickly and efficiently than running everything through the state. There are also significant spillover effects because often when empowered local litigants go into court and sue, they are able to obtain injunctions that prohibit the action on which they were suing on statewide. A good example of this is when the city of Los Angeles sued the Albertsons grocery store for illegal dumping. They were able to obtain not just a monetary judgment, but also injunctive relief, which prohibited them from engaging in those practices statewide. So, even if you're not particularly concerned, although I think you probably are, if you're the California state government about what's going on in Los Angeles, this has statewide effect. Obviously, another issue is resources. all of us in government offices are stretched thin. We had discussions yesterday about how local governments and state governments especially are relying on private counsel, contingency counsel, to address those resource issues because you can't do everything in-house. Well, empowered local government, particularly if they are addressing issues of local concern, is one way to get around that resource issue without spending money out of the state fisc on private attorneys. And then the final reason that states may want to empower local litigants is sort of a laboratory of democracy approach. Local litigants may bring lawsuits that a state AG may want to step back, wait and see if the legal theory has a chance of success. It may be addressing a problem that the state would want to address, but there's some uncertainty about whether the facts are there, whether the legal theory will hold up. And allowing local units of government to do that gives states the information that they may need to make a more informed decision as to whether that type of litigation, whether that way of solving the problem is something that should be done on a statewide level, or whether indeed the suit fails and there needs to be a different way through legislation, through regulation, through some other means of addressing that problem.
Let me just say one quick, you were talking about the gun legislation, right? And in actuality, on the opioids front, a similar thing has been done, right? And there are multiple states that have either passed or have proposed legislation relating to use of opioids funds. The one that comes to mind is Indiana, but there are multiple states that have done something similar or created opioid abatement funds that are limiting lawsuits from being brought by local governments and or directing how to utilize funds coming out of opioid cases. And I just say this, that is a clear-cut fix. State legislature speaking is always what I didn't tell you is my first job was in the state legislature in Illinois, where I worked on the impeachment trial of Rod Blagojevich. So we could talk about that some other day. But state legislature speaking is a clear answer, but it's not an efficient answer. If we're saying every time we have an issue of statewide interest, or an issue that affects the whole state and possibly, and in reality, the whole country, we need to go to every state legislature and ask local governments to stand down. That is a waste of court resources, because in the interim, those cases are being filed. In fact, even with those state statutes being put forward, local governments are still continuing to file lawsuits. So, it's inefficient. It's just inefficient. We're still asking courts to make decisions even in light of the state statutes.
Great. We have about 15 minutes, and we have lots of questions, and we also have lots of questions from the audience. I want to make sure we get the audience questions answered. So the first one, I think, will kind of dovetail nicely into something that Chip said that I'm not sure everyone else is going to agree with. So the question from the audience is, so is the premise that state legislatures are the key, and legislatures shall determine the extent of any such delegation to local governments? And related to that, are there constitutions that you're aware of that provide kind of robust areas for locals to kind of play in this field? And this is all in maybe contra to what Chip said, which was that AGs control the authority of locals under this doctrine. So Maggie, do you want to address?
Sure. It would seem to me, so I have not done a state survey of constitutions, but it does seem to me that I think I'm on the same page that Ellie is, that how states decide to constitute their own state government is absolutely a question of state law that can be answered differently, and that means that the delegations can be through a state attorney general's office. They could be outside of it through a legislature. They could be because of custom, looking, I think, a sort of a common law-like version of it in which states customarily have invited or allowed these suits over time, and that power has developed. So I think all of the ways that states govern themselves are on the table, and there is not a clear reason to me to take the ability to constitute themselves away from states in whatever manner they want to do.
Yeah, and I don't think I intended to go that far or did. I think what I'm saying is that sure, legislatures can do things, and I think Delaware has. I think California has to some extent, given some Parens Patriae authority to local governments. But what I'm saying is that that cannot deplete the Parens Patriae powers of the executive, the state executive, and that when the state attorney general chooses to step into the sandbox and play, the local governments have to go the same direction, and they can't be doing something different. And certainly it's not the business of a federal court to be involved with deciding how money that's coming into a state is divvied up between a state and its political subdivisions. I guess specifically with respect to opioids. So, in Ohio, I would say the Attorney General's office wasn't necessarily happy with what happened with the tobacco money. And, Attorney General Yost, got together with Governor DeWine and, came up with a political solution with local governments about, how the money was going to be spent. So, we did enter into the settlement with the distributors, and we got all of their state governments to sign on to that. I think maybe there's a couple of holdouts, but if so, it's just one or two. And we have an agreed framework for how that's going to be distributed and used, a certain percentage to the state, a certain percentage to local government, and then this kind of foundation that's being created to get money to where harm is best. Is that going to be a good solution? I don't know, but it was done in reaction to what happened to tobacco, and hopefully it works. So there are solutions, but they're political solutions to problems like that, and they're not court solutions to come in and decide these issues of allocation.
Yeah, I'm not sure I have a ton to add. Of course, I think I agree with Maggie that all sources of law are on the table. Certainly, a state constitution is superior to state statutes. I am aware of, I mentioned home rule previously, and that broad home rule delegation to local units of government has been interpreted, at least in Delaware, to include Parens Patriae authority. Home rule can be something that is in the Constitution and usually also by statute. I know at least in Michigan there is a home rule provision of the Constitution, which and then in turn there's a much broader Home Rule Cities Act, which fleshes that out. So absolutely, I think this.
But typically, even with home rule, I mean, isn't it true that if the state acts, typically then that will sort of preempt those laws, those local laws? I mean, just like with respect to the gun litigation.
Sure, and I think and I think that the point of disagreement that we may have is just what constitutes state action sufficient to displace a delegation of power per home rule. I don't dispute. There's no question that a state at any time through the proper state legal mechanisms can take away any or all the powers that it's previously delegated to local government, just like in the gun case. My proposition is just that if you have a state legislature or a state constitution that has said local units of government are able to exercise X authority, then absent a enabling statute that allows the attorney general to come in and say you can't exercise X authority in this particular case, then you'd need a change in the law. Now, what I will say too, and again, I know most about Michigan because I'm from there, but it's not in Michigan there are cases out there that basically take your position that says that the Attorney General can come in and displace local units of government in lawsuits, but the way in which those decisions have been made by our state Supreme Court is by reference to laws which empower the Attorney General and which make, in the Supreme Court's eyes, clear that the Attorney General has that authority. So again, it's, I think my proposition is just that we need to resolve these questions through reference to state law, whether that's constitutional, whether that's statute, or whether it's any other source of state law.
One of the questions from the audience, as a practical matter, can local governments enter into a global settlement for the sovereign state? Are there any instances where that's happened, or do the courts understand that this local is just acting for itself and it can't go beyond that?
I think that kind of gets into the problem that Vaishali was talking about. So you have you have these defendants, who we've sued and who local governments are going after, and it's a case where you actually have to achieve global peace. It's a buzzword that's out there, but a lot of times you've got different interests, and you're saying you want global peace because you want to resolve them all at the same time or near the same time, but sometimes you can peel them off this way or that way. In this context, it's really hard because you have different entities that are asserting the exact same claims on behalf of the exact same people, and I'm going to walk into the room and I'm going to tell that defendant, like, I don't care, like what you settle with with the cities. Like, that claim belongs to me completely and entirely. And so, you can pay them, but you know what? You have to pay me in full. Because, we have to maximize our bargaining position. And I'm sure the cities will take similar positions. And, when they negotiate with us, they come to us and they say, listen, I mean, look at the opioid framework. The amount of money that goes to a state is dependent upon the amount, the number of political subdivisions that they get to sign on to the settlement. And so, it makes it very, very difficult, and it makes it very complex. And that's why, even though there's been, a meeting of the minds with the states and the defendants in those cases, there's still cases being tried.
Couple quick add-ons. I think Delaware must be in the, I have looked at a lot of states on this issue, and I think Delaware must be in the minority in terms of a true delegation of power that way. There are certainly areas where I think states and local governments have concurrent authority, and there are definitely, state-specific statutes that say, local government, you can similarly sue on behalf of the entire state for a particular activity. I think this is particularly, so the answer to the question is, it's possible under a particular theory, depending on what the theory of liability is, that a local government could resolve an issue for the whole state, but it's pretty narrow. And I think the point here is really, is that possible when the AG takes an action? And Chip and I are probably saying similar things, which is, in the majority of cases, no, there may be some narrow ability to do that. And I'd frame home rule differently than Ellie does. I'd frame it as a narrow doctrine, not a broad one. But the city of Chicago may disagree with me on that one. So
there's one particular aspect of these opioid cases that makes them very much different than tobacco, and maybe more like asbestos, which with tobacco, you really do have bottomless pockets there, so they're able to pay. These opioid manufacturers and distributors, they don't. And so, if you have 3,000 counties, 19,000 municipalities, 16,000 townships, 80,000 local governments in whole, trying to get part of this, nobody is going to get paid in full on this. Nobody is. And so you've got this, the more actors that you have, the more incentive you have for those who are teed up for their trials to go first, to go and get their share. And, they can go and they get these big verdicts, and they get paid in whole or closer to whole, and there's less that's left for everybody else. And how do we as a state of Ohio go and tell Cuyahoga County, like, sure, you just got this great settlement because you were teed up first, but we're taking that money away from you to give it? I mean, we can't do that. And so, there are, real problems that come from the finite resources that are available in these cases.
So
yeah, and on the defense side, I mean, it disincentivizes you from agreeing to a large settlement. I mean, it's pretty simple. If you know there are big, large buckets of outstanding liability, you can't expend all your resource on one settlement even if it's with 50 state AGs, you just cannot do it. It's basically malpractice to advise your client that way. So, I mean, it's just a practical issue. If you know there's outstanding liability, you need to make sure it's covered somehow. And just like we're seeing in opioids, it's complicated when you're asking that level of coordination at the time of settlement.
It's probably worth adding that state preclusion rules are going to kick in terms of the scope of these settlements as well. It's not going to be one universal, one-size-fits-all preclusion rule, but you're going to have to look at state claims and state preclusion rules. And they're fraught and they're unsettled. And I think there is a very real risk for defendants in knowing how much preclusive effect they're going to get out of settling with the state's largest city. Is that making all of the claims in that city go away on a pro rata basis for the share, or is there still going to be some part of those claims that lives on with the state? That's a tough thing for defendants to figure out.
So we've talked a lot about the vertical relationship between states and locals. One of the questions from the audience members looks at it from the federal to the state. Does the federal government have Parens Patriae authority that preempts the states? And I guess related to that would be, can the federal government restrict or expand a state's Parens Patriae authority? I think this was touched on in your paper.
Sure, sometimes Congress comes in and creates a right of action and says the state attorneys general will have the ability to bring that particular cause of antitrust as an example of that. So Congress can do this when it creates a right of action, but that's about it for Congress. Other than that, if it's a state claim, I don't think it's up to Congress to figure out who gets to bring it.
Yeah, but I mean, interestingly, that there are federal statutes that specifically mention state Parens Patriae authority when they're, it's saying that the AG brings those suits.
So this might be our last question, and it might be the one that's unanswered, but we have a bunch of judges in the audience, and one of the questions that we might have if faced with a case like this is, what if you have a state that in its statutes specifically grants locals this authority in one particular instance, but then specifically excludes this authority in another instance? What do we do when the statutes are silent? What is the default rule on whether states have delegated this kind of authority to locals? And does it matter if the AG comes in and takes a position in that situation? Maggie?
What do you do when statutes are ever silent, Judge?
You tell us.
When statutes are silent, you do the best you can, right? You look at history, you look at practice, you look at custom, and I think you might not have the same answer to what silence means in each state. I think silence would mean something different in Louisiana under the Napoleonic Code than it might mean in Michigan.
Elliot?
Yeah, and this is the question that comes up all the time, not just with respect to local units of government's litigating authority, but with their legislative authority and whether they can take action generally. What do you do when it's silent? And it gets complicated, but in general, there are two ways in which local governments are organized within states. One being home rule, where the default presumption is that you have all the powers the state has, unless the state has pulled them back. The other is Dillon's rule, where the default presumption is that if we didn't give it to you, it's not included. Now, those get complicated because some states say that they do both. They're a Dillon's rule jurisdiction, but have a home rule statute, and you got to figure it out, I guess. But those are the two default presumptions that I think start the analysis when determining whether a local unit of government is empowered to do something under state law.
I just wanted to kind of get back to the preclusion issue. States can preclude, the claims of local governments, and there was a series of cases I call the school milk cases. There's this antitrust violation, and all these dairies were charging too much for milk. Back in the little carton days before even they had the strawberry milk, and so like the state of North Carolina went and settled, and then these school districts sued, and the court said you're out of luck, that the state sued or settled your claims for you, and that's the issue that Judge Breyer has teed up for the MDL that he has.
Yeah, and there's a lot of cases like that. I mean, the Biltmore case in the Fourth Circuit for the dairy producers isn't the only one. It happened in the Exxon Valdez cases, I think in the Ninth Circuit. The court said the Attorney General is the entity that should deal with the public interest. It happened in the tobacco cases in the Michigan Supreme Court, where the Michigan Supreme Court told local governments the AG's already acted here. So I think, where it's not clear, it's really important to go back to some of those fundamentals. One, who is the chief law enforcement officer of the state? Two, what are the interests actually being litigated? In a lot of these cases, you'll see the local governments are attempting to litigate a statewide interest. So is that the appropriate entity to decide relief for the whole state? Are they able to, just as a practical matter, understand and know all the relief that the state is entitled to? And yeah, it's really helpful to have AGs speak out on the issues and sort of, state very clearly that where they have spoken, they intend for that to be sort of their ability to exercise power for the whole state. I know it's not possible in every state, totally understand. There's a lot of dynamics that go on between local governments and state AGs, but where possible, certainly come talk to me. Certainly come talk to me.
I think we're going to have that be the last word on this. So everybody who has questions, just go talk to Vaishali. Vaishali, Ellie, Chip, and Maggie, I want to thank you for participating today.
Absolutely.